All right, so as Rosemary introduced, my name is Georgina Rodriguez. I am 21 years old and I'm a full-time student at Hillsborough Community College. And I also work within our local child welfare system. But today I stand here as a former foster youth. As Rosemary also said, that I entered foster care right here in Hillsborough County at the age of 6 and aged out at 18. And throughout my 12 years in foster care, I lived in about 7 different placements, often separated from my older brother, who was also in care. And throughout my 12-year foster care career, I had some really good and some really bad experiences growing up. Some of these would include, but not including but not limiting to having to visit my biological mom for years, one who I was deeply afraid of because no one listened to my concerns. Or even not only was I separated from my brother, but I couldn't visit him on a regular basis, who up until the age of 6, I lived with every day, saw every day. And then when I entered foster care, I only got to visit him based off of convenience. Or even problems in a home. Problems in a home in which myself and other youth living there were physically and emotionally abused on a regular basis because we didn't have the courage to speak up. So my work within Florida Youth Shine as a local chapter representative and statewide legislative chair, I have learned a few things. I now know that youth in dependency in the dependency system are a party to a case, but they are often without legal representation. I also know that youth in the dependency system are often getting involved in delinquency acts for various reasons. And when I think of Delinquency Act, I often think back to the stories I hear from my brother or my foster siblings or even peers from across the state where they were involved in or had some kind of DJJ history. And some of these would include hanging out with the wrong crowd and then not knowing where to turn or who to talk to about it, or even circumstances in which they were living in a home and the cops were called out because they got in a physical altercation with someone in the home. Not to mention, you have labels and stigma along with being in the dependency system and being in the delinquency system. So now you guys are sitting here getting ready to do a training, and I applaud you guys for sitting here and about to be educated and learn something and use your legal knowledge to be advocates for those youth in the dependency and delinquency system. I know that with you guys on their behalf, or hopefully you guys will continue to do this, their hopes, their dreams, their concerns won't fall on deaf ears. And not only that, you'll take their hopelessness and turn it into empowerment. So thank you.
And I want to thank you in particular for undertaking Crossroads. I mean, it has already made a huge difference with several of the kids that we've had in a very short time. I don't think it's been 6 or 8 months. And there are a couple of kids whose lives have been really changed much for the better. So I thank you, and I thank all of you for agreeing to undertake this. Pro bono work is something that the bar and that our profession requires of everybody, but this particular branch of pro bono work is very important in a way. It's the most important. I went to a luncheon that was sponsored by, of all people, the United States Army Recruiting Command, and the commanding general of that entire command was coming to the community to try to recruit people to go out to the high schools and recruit the best and the brightest for the Army. And he said something that really stuck with me. He said, "Kids, that's our real infrastructure." And it's true. And that's why you all are so important, because what you're doing is really kind of infrastructure building or infrastructure salvage to a certain extent. Let me tell you something from a judge's point of view. I have been in every division, including probate. And when you're a judge, because we're not concerned with the outcomes of cases, we basically just referee them and process them. The only thing you ever count is your caseload, because you want to know that the cases are moving by fast enough and that people aren't getting stuck in your division for a long time because you're not a good manager. That's all you ever count. When you go to delinquency or dependency, then you're counting much different outcomes. Then you have a caseload of little human beings, and you begin to feel that you want those kids to be successful. And so I start to count the kids that age out, that are on the way to college, that don't have drug problems, that don't have their own children, that are successful. And now I have a different measure of my being a judge than I would otherwise have in any other division. And I think for you, you may find the same thing. For many of you, if you undertake this and stick with it for a while, you're going to have some real frustrations. You're going to have a fair amount of your kids that just blow up on you, no matter how hard you try, how much you love them, how much you want things to work out for them, whatever sacrifices you make for them, however you stick out your neck for them, they're just going to blow up. And that's just the way it is. To a certain extent, working with teenagers that are in our system, or working with teenagers in any system, is like trauma surgery. You know, you can either do it or you can't, because you don't always get a great result. But you do get enough good results that you feel like you're making a real positive, not statement, you're making a real positive move. You're making a real difference in society. In my division, I see what really I think is the cross type of any kid in the delinquency system. When you look at the histories, if you take the time, if the system takes the time, if the judges, the prosecutors, the public defenders, the DJJ workers, law enforcement, if they take the time to really look at most of these cases, you find that at heart, many delinquency cases are just undiagnosed dependency cases. That the child is there not because they're just innately bad and love to steal cars, or they're innately bad and they love to get in fights at school, or because they just need to smoke a lot of marijuana and become addicted. You know, they're there because the other parts of their lives weren't really hooking up the way they should. And so you would be another set of eyes for these kids, and you would be able to maybe salvage some of the kids that otherwise just didn't really get a good enough look at. And I'll tell you two case histories that I think illustrate this. When I first came to my division, the crossover division, one of my kids came every 6 months in dependency. A child has come for what's called a judicial review. And these two kids would come up together, and they always came from the Hillsborough County Jail. And one was 15, one was 16. And after a while, and I would then I wouldn't just do it every 6 months. I'd set them down a couple of months out or a month out so I could see, because I kept waiting for them to get out. Damn, man, 6, 8 months went by, they didn't get out. And they were not there because they had murdered anybody. It wasn't a sexual assault. It wasn't anything really scary. What it was it was a burglary in which a gun had come up stolen. And in the criminal justice system, the penalties are the same if you happen to be 15 years old and you break into a car or an apartment and there's a gun there and you take the gun with you. That's just the same as if you were a home invader and you armed yourself and broke into somebody's house. It's like a 20-year felony. And so these kids have been charged as adults. And what they had actually done wasn't that big a deal, except the older one had a long history. So he dragged the younger one with him. So I didn't know what to do. For the better part of 7 or 8 months, I was just pulling my hair out, trying to figure out what I could do for these kids. So finally, I appointed him an attorney ad litem. I think I got advice from one of the judges that's very seasoned in delinquency, because guardian ad litem couldn't do anything. I finally appointed him an attorney ad litem. And I went out of my way to find attorneys ad litem that were friends of mine, and they were seasoned, older lawyers with lots of gravitas, and one was a very well-known criminal defense lawyer. And within 2 weeks of them showing up, these kids were out, and I thought the judge made a mistake, for what it's worth. Someday somebody will talk to you about that. The judge gave them the choice. Judge said, look, fellas, you can either go to a moderate commitment facility or you can go on adult probation. And so they both picked adult probation. One made it, one didn't. And I teach judges. I also teach in new judges school. And I teach the judges, look, don't give the child the choice. You know, the child would much rather be on adult probation. And they don't want to do 6, 8, 10 months in a commitment facility. But really, if that's what they need, you got to do that. You got to do that. But without another set of eyes, without another attorney there looking at it from another point of view, it's just simply not going to get done. So because of those attorneys at Lytton, at least one of those kids got a shot. The second story I have, I had one of my girls who was a very young girl too, 14. She was had been in a residential mental health facility, Manatee Palms, a lockdown psychiatric facility. And she had escaped with a couple of other girls, and they had been picked up by some sex traffickers. And that was the word we got back. And so there's an FBI task force about that, and everybody was alerted. And finally, about 6 or 8 months later, one of them pops up. And she is in juvenile detention in Sarasota. And this is what the criminal report affidavit said, more or less. The victims reported their car had been stolen. And the defendant was found in the car 2 blocks from where they were. And so they arrested her for car theft. And it said she had been staying with them for a couple of weeks. All right, this is a 15-year-old girl, foster child, runaway foster child. Obviously either trying to get away from these people or just maybe taking their car. Nobody picked up who those people were and why she was probably there. So, had she always had an attorney at Lytton who at least had the time and energy to follow everything that was happening to her, someone with some gravitas could have gone down to Sarasota and explained what looked like a garden variety car theft wasn't that at all. And we didn't get a good result in that case. But it may have made a huge difference. So I probably talked much too long, Rosemary. And that's pretty much it in a nutshell. I was telling my friend Jerry Gewirtz there, my observation after all these years in the system is that this system, the criminal justice system, the dependency system, the delinquency system, becomes a process, where the cases are processed as quickly and as efficiently as possible. And at this time, I'm convinced that if you want to get better outcomes, better results with kids, you can't just do it as part of the process. It's custom work. Every child is an individual. Every set of facts is individual. And so it has to be slowed down and looked at and made a piece of custom work. And without extra eyes on it. Because I tell you, the state doesn't fund. The state doesn't fund enough PDs and state attorneys and JPOs and caseworkers. They just don't. And so another set of eyes can be a real lifesaver. And that's you all. And I'm very, very grateful that you've agreed to do this. So thank you very much.
Good afternoon, everyone. First, I want to tell you that everything that Judge Stoddard said, he's absolutely correct in encouraging you guys to be a part of these kids' lives. My name is Eurydice Barton Jones. I'm an assistant public defender. I work at the public defender's office here, 13 Judicial Hillsborough County office, and I've been doing this for now probably about 7 years, working in the Unified Family Court arena. And when the division first started, we had maybe about 1 or 2 cases. And a mandate came down from, I believe it was Justice Periente at the time, and they wanted to start what was called Unified Family Court, because what they were recognizing was you had kids in the delinquency system who had dependency hearings, and the left hand didn't know what the right hand was doing. Kids were getting lost in the system. Kids were not showing up to court hearings. In the regular delinquency arena, we had cases where Kids had caseworkers, they were in foster care. No one knew where the kids were. No one knew that the kids who were on the docket for that day was kicked out of a foster home the night before, so their placement changed, and as a result of that, they didn't have anyone to bring them to the court proceeding in delinquency court. The kid would get a pickup order, an arrest warrant would be issued. The child would get arrested at school or at wherever they're located out of county or in their new placement. Victimized all over again. And in the wisdom of the Supreme Court of Florida, they saw that was happening and it was becoming a big issue for the state of Florida. So they came up with the idea of the Unified Family Court crossover division. And ever since that happened, that has been a great success in that we now can track our kids. We now know that when a child doesn't show up for court, it's not because they didn't want to be here today. Sometimes it's because the caseworker didn't know. I've had kids come to my office, appointments, the day after they were kicked out of their old placement because the placement got shut down by DCF, and overnight they had to take everything that they had in a black plastic bag and was told, you've got to go to a care center to spend a night. And you've got the kid asking the question of, where am I going to live? Where's all my stuff? They came home from school one day and they've had a sheriff out there waiting for them to take them to a care center. Their lives get disrupted constantly. The school that they used to go to that was close to where they used to live, now they've got to have a change of placement, which means they're going to be out of school for about 30 days before that change of placement happens. There's a lot that goes into managing a child that's in the dependency system. And that's why we are saying to you guys, the fact that you're here and that you're interested is awesome, because they need you. And it's going to be some very rewarding work for you. And one of the things I want to express to you is that you're making a good decision to share your gifts and your talents and your resources with these young people. You're making a very good decision. It's going to be one of the best decisions that you will make in your legal career. And I will also tell you, as Judge Stoddard says, it can be very frustrating at times. No matter how much you do for them, the return may not be what you expect it to be. But you have to remember and understand that their life story was not ours. And I often tell my kids, and I call them my kids, I often tell my kids at 13 and 15 and 16 and 17, they've been through more than I've been through in a lifetime. And they're surviving. So I find them to be amazing. And I represent them in the delinquency arena. So they're not coming to me perfect. They're coming to me with charges. They're coming to me with bad on a Leo, domestic violence battery, petty theft, grand theft auto, you name it, sexual battery. Yeah. They're coming to me, mental health issues. They come to me imperfect. But with all of that imperfection, I remind them that they are perfect to me. And I fight for them. And I think that it's important that as we, as attorneys, what we have to remember, we have to fight for them. Because they tend to feel like they don't have a voice. And they've got to know that they do have a voice. Even if it's through us or through them speaking up. As Georgetta said earlier, with her and her siblings, they didn't speak up. They didn't feel safe to speak. That's why they didn't speak. You've got to make your kid feel safe to speak. And you have to be ready to hear what they have to say. Sometimes they're going to tell you TMI. That's too much information. But it's okay. It's okay. Because when they start speaking, it's important for you to start listening. My interaction with them as a defense attorney in the delinquency proceedings, one of the things that I want to share with you, when we first started this division, I was having a lot of pullback with the case managers when I would tell the case managers, we have to set an office appointment with my client so we can discuss the case. And I would get a look. What do you mean an office appointment? Kid got arrested. Kid did it. I said, well, you know what? My client has rights. And I'm a protector. I'm a gatekeeper of those rights. So it's not about a child getting arrested. The buck doesn't end there. If you as an adult get arrested, the first thing you're going to be crying is, I want my lawyer, and I have rights. Well, these little people have rights too. So I had to send that message home all the time to my case managers, letting them know that, no, this is not an arrest and then plead a kid out. I never get to meet the kid. I never get to talk to my kid. I don't know what their history is, their background is. So from early on, some of the things that our office really puts forth, which is interviewing the child, making sure that you talk to your client, you know the facts of your case, you find out whether or not you have mitigating circumstances, defenses available for your client, all of those things, that's what I do. And I don't practice any different, regardless of whether it was a dependent child or non-dependent child, because children have rights. And one of the things I found fascinating in working with this clientele, they didn't realize that they had those rights. Because again, not having people fighting for them, not being accustomed of being fought for. So I train my kids and I let them know you have rights, here are your rights. I would explain that to them very thoroughly. Before Judge started, it was Judge Bauman, and Judge Bauman would make the caseworkers bring the kids to my office appointments to make sure that they had an opportunity to sit with their attorney and talk to their attorney about the case. And that's how we got started. We had to make sure that that was being done. And I had to fight for that. And one of the things that became very apparent to me as well is that in doing that, the dependency case would sometimes, many times, slow down the delinquency case. Because if you have a kid that you're working with on a Monday, and then 2 weeks later, the placement changes, and then now you can't find your kid, or you need to contact a caseworker who has all of a sudden resigned from the post, then you have those issues that come into play as well. So the consistency of placement and case management was just not there. And it's gotten better over the time period, but those are some of the frustrations that you deal with. You can't find that consistent person to deal with on a regular basis. And from experiencing that, I began to realize that consistency is important to these kids' lives. So having the one judge constantly in their life, now it's Judge Stoddard, which he doesn't, I tell him sometimes, but not all the times, the kids love him. They think, some of them think he's Santa Claus. And, you know, they enjoy working with him. They feel like he cares. They like going before him and telling him what they want. I always encourage my kids to tell him how they're being treated. If I have a kid that complains to me about a caseworker, listen. Please listen to that child. I'll try to do something about it if I can, but I always report back to the judge if the kid's not happy about something that's being done. And you've got to protect your kids from at the utmost. Another thing that I interact with, I work with a lot of different attorneys, the Attorney General's office, the state attorney, which is a given because I'm the defense attorney in the courtroom, the attorney ad litems, and also the guardian ad litem attorneys. You know, we tend to work together a lot in trying to get the best interest and the needs of the child put forward. That's important. And again, that's dependency trumping delinquency. I think a lot of times we try to handle the case from the standpoint of separate entities, but you find out real quick that it's really a body. Because when you have a child who has a mental health issue and they need to be in a SIP placement, you can't slam them with probation and they're dealing with mental health issues. You know, you have to look at the totality of the circumstances and you have to deal with the child from the standpoint of a holistic approach. And that's the approach that the Unified Family Court in Judge Stoddard's division brings to this arena. And as he said, it's very important for you guys to be able to recognize that the needs and the wants of these kids are being met. If you have a child that tells you that I got moved from my placement, I don't have any clothes, that's why I'm not going to school, okay? That's an issue. Because then a probation officer is going to say to me, well, I'm violating your client because he's not going to school. And then I'm going to say to the PO, but he doesn't have any clothes, or she doesn't have any clothes. And that's why they're not going to school. And then I'm going to ask the caseworker, well, what are you doing about this issue? Because now it looks like the kid just doesn't want to go to school, but the kid has a point. He got moved the day before. His clothes is nowhere to be found. Would you want to go to school smelly and messy? If you don't want your kid to do it, why do we expect our dependent kids to do it? So this is the kind of stuff that comes into play a lot of times, sometimes in some of these hearings. And that's why, again, dependency sometimes will trump delinquency. Also, I want to talk about runaways. A lot of times, kids run. And I know that it's heartbreaking at times when they run. They'll stay for 30 days, for 40 days, and we'll get excited. They stayed put, and they ran away. Well, I'll tell you what. That's why it's important for you to create a rapport with that child, because what you'll find out is they may run from the placement where they are because they don't want to be there because they're not being treated right, but they will call you. And they'll make your office appointment, which tells you a lot about your rapport with the child, okay? So they run, they disappoint, and a lot of it has to do with running from their past. You know, they've been through a lot, and you've got to know the history of your child. That's very important, because knowing the history of your child will help you to determine what type of a rapport you will have in the future. Okay? And don't be hard on yourselves. The fact that you're there, that you're volunteering your time, your gifts, and your talents, that in itself is awesome. And you're going to make them feel good to know you don't have to be there, but you chose to be there. You're going to love these kids. And if you find a kid that you're working with that you're not a good fit with, see if there's somebody else that might be a better fit. But whatever you do, don't give up on them. And they will push your buttons to see if you will give up on them, because that's what they're accustomed to. And if you're in it, they'll know. And I just want to, in conclusion, remind you something that Georgetta said, which this was so interesting because I wrote it down earlier before I came here. I said, you're saving a life and you're creating hope in a young person where there was no hope. That's what you guys bring to the table. Listen well when they choose to tell you their story. Trust comes slowly, but expectations must still be high for them. And tell them, remind them, this is what I remind my kids of often, not to sabotage their future based upon someone else's bad choices from in their past. Okay? They didn't ask to be in foster care, but they're here, and we're here to help them to be successful. Thank you.
I'm actually probably not going to give an overview of the dependency system in Hillsborough County because I asked Rosemary to send me the list of who's coming, and you guys took the training either here in person or you've taken it online or you have experience in dependency. So what I want to really focus on is you heard from Yuri kind of what a crappy job the state does when it's a parent to children that are caught up in the delinquency system. And it's tragic when we have kids who don't have their parent there advocating for them, helping their public defender get the best outcome for them. But what I want to talk to you about is the resources that are within the existing dependency system that, even though as individuals we don't do a good job parenting, there are resources that you can access through dependency that can help you help the public defender do a better job for kids. And that's really what I want to focus on today. The first, in the training materials for the dependency step-by-step training, was an overview of the system. There's an organizational chart with Eckerd and the different players and the community, the care centers. You already talked about kids getting picked up and taken to a care center. The care center is the house for the child's record. And I want to reiterate part of what I talked about in that previous training about your role as an attorney. Whether you're an attorney for a kid or whether you're an attorney for a corporation, you have the same duty of zealous advocacy, of loyalty, and of competency for your clients. And when you get a new case, whether it's for Xerox or for a kid, you need to find out everything you can about your client and what's happening in that case. And the starting point for that is the child's records. So in this handout I gave for you today, Dependency Resources for Crossover Kids, is the statute we actually helped get enacted because kids and their lawyers were having a hard time getting access to the records. So we made it really clear. Kids in foster care have a right to their records. Their attorney has the right to the records. You have a right to a copy of it without paying a charge. So the folks at the care center know this. You need to find out which care center your child is assigned to. You need to get a hold of the record and understand the record. When you're looking at the record, there's some really important things you want to be looking for that's going to help you understand your child and how you're going to advocate for the child. The first thing is the shelter petition, because that's going to tell you what allegedly happened that brought the child into care. Somebody's version of facts that of what's occurred to the child. The second is the Comprehensive Behavioral Health Assessment, CBHA. And on this one-page handout, I've given you the link to a document that describes CBHAs a little more in depth. That's available, all these resources are available on the Florida's Children First website. The CBHA is kind of a biopsychosocial. When children first come into care, we're going to take a look at where they're coming from, what's happened in their lives, existing psychological reports, existing evaluations, talk to the people that know them, talk to them, and try to get a picture of their life. They're done by licensed mental health professionals. They include recommendations about what this kid needs. CBHAs were created as a consequence of the ME lawsuit, in which I participated in at the conclusion of, which was kids are coming into care with mental health needs that aren't being met. And so the state said, okay, we're going to take a look right when they come in and see what are their mental health needs, make recommendations, and get them the services they need to address those mental health needs. CBHAs are supposed to be done within 30 days of kids coming in care. They can be done subsequently. They're paid for by Medicaid, and Medicaid will pay, if they're needed, for at least one a year. If a kid's been in for a long time and there isn't a current CBHA, in the dependency case, you can request that a new CBHA be done. Somebody needs to take a macro picture, somebody's not involved in the case, and look at what the services and the needs are. And I will tell you there's a trick with CBHAs I learned from talking to an assessor. At the end of the CBHA is a list of recommendations. And the recommendations are supposed to be incorporated into the case plan for the child, and they're supposed to be done. One of the assessors informed me not too long ago that she was instructed that she could not put things in that set of recommendations that would be mandatory actions for the caseworker to take. So things that she felt were important but would be a requirement on the caseworker couldn't be in that set of recommendations. So she puts them in the narrative of the CBHA. All of that by way of saying, read the entire CBHA. Look for all the nuggets, not just the set of conclusions at the end. And that should give you guidance. And if there's a recommendation in there for family therapy, and your kid was arrested for getting into a fist fight with their sibling, and there never was family therapy, you've got a hook, right? This was identified. This was identified X number of months ago. The system never provided these services. Let's get on it. So that's a resource that you can use to identify what someone else has seen as needs and whether the services that were identified have been offered. Likewise, the case plan. This is supposed to be the governing document. This is what, if the parent's still involved, what the parent is supposed to be doing to get their kid back. and what services are supposed to be provided for the child. So are the services in the case plan being followed? If not, let's push for them to be followed. If what's in there isn't good, then let's change it. If it's, things are not necessary, take those out and put in what the kid really needs. Another item you want to look for in the record is the JRSSR, Judicial Review Social Study Report. These have to be filed with the court. A lot of times we'll see it's the same language over and over again with a little bit added at the end. And sometimes there are really inaccurate things that are in there, but sometimes there are good and helpful things in there. The guardian ad litem report will also be in the record. What are they saying? What do they review? What are their recommendations? So those are some of the things, not all, some of the things you want to look for in the kid's record. So that's one set of resources you have. Another set of resources you have for our kids in care, almost all of them get Medicaid. Medicaid in the United States is Early Periodic Screening, Diagnosis, and Treatment, EPSDT, which is gold standard health insurance, if we make it be gold standard health insurance. Anything that a child needs that's medically necessary is supposed to be provided for by Medicaid. And so if we have unmet needs and services, there's a tool to fight for what your kid needs, that maybe they can't get in the delinquency system. You ought to be able to get it through the dependency system and through fighting for Medicaid. Medicaid pays for inpatient psychiatric treatment, therapeutic, foster, and group homes. Those might be the alternatives that the public defender needs to fight in a crossover case, to say, don't lock my kid in a commitment facility. Really what they need is this kind of treatment. Let's do it through the dependency system. Medicaid is a tool. And then finally, the next main tool I want to talk about is money, their allowance and their master trust. What are the kids doing? If you're a teenager and you're getting $15 a month allowance and you are not living in a place that's going to let you work, is it any big surprise that you might engage in illegal activities to gain resources, right? I mean, we don't set up kids in a good way. So make sure they're getting their allowance. If they have a master trust, because they either themselves are getting supplemental security income or they're getting a derivative benefit from a parent's death or disability or retirement, there's money sitting in an account for them. We call that master trust. The reference on the sheet that you have is our money book, the Know Your Rights money book. That'll tell you more details about what that is, how you can access it. So I've listed a few of the other resources from our website. There are a bunch more resources that are in your original dependency handout book and a bunch more on our website that you can search for by topic. So those are just some of the things tools that you can use if you've got a kid in dependency with delinquency charges. Those are the dependency resources. Later this afternoon, you're going to hear from my colleague Walter Hahnemann about how, as a civil attorney for a child, you can best work with the child's defense counsel. And I'm going to leave that to him. But I'd be happy to take your questions about these dependency resources or others. Or question?
Yes. Do you know if Medicaid also covers diagnostics for behavioral behaviors?
Yes. Again, if it's a service that needs to happen, it should be covered under Medicaid. In Hillsborough County, the child welfare system is part of the Child Welfare Prepaid Mental Health Program, CWHMPP, whatever. It's a partnership between the community-based care agencies and Magellan, so a lot of times you'll hear it called Magellan, and that is the provider for behavioral health or mental health. But they have to go under the Medicaid requirements, which are in a handbook called the Community Behavioral Health Handbook. It's part of Medicaid. It's on the ACA website. It'll tell you what they cover and how to access it. And if you have particular issues, we certainly can help you identify the right assessment and getting to the right person.
This is a question kind of going back to Yuri's talk, and what would be our ethical obligation if we have a report with a child who has a pickup order and the child contacts you, and do you have any, does the attorney, can the attorney hold that confidential, or does the attorney need to report that to the case manager and others in the system?
The law is, I believe the law is clear. A case went up on appeal and the appellate court ended up dropping it as moot. If your client discloses their whereabouts and tells you that it's confidential, that's a confidential communication you're not entitled to disclose.
It's a practical question. I generally tell our attorneys that when they want the case records for their client to go to the clerk's office in the annex, is there some, are the records of the care center more comprehensive?
Much more comprehensive. Because the clerk's office is going to have everything that was filed, but all these reports are not necessarily going to be filed, and other information that might be in there. So if it's easy to get down and flip through and get important documents from the clerk's office, I'm not saying you shouldn't do that. The case file should be more comprehensive.
Back to the Medicaid, if we feel that we need to get some kind of service for, care for our child or client, I guess if it covers it, but how do we get to that point? Like, is there a form we fill out and give someone, or do we just tell the case manager that we need to get Medicaid, or how do we kind of get the ball rolling?
Okay, well, your kids should have Medicaid, and unless they're immigrants, in which case the CBC, ECRT has to pay for their medical care. If the kid, has a bloody nose or whatever, you take the kid to the doctor, right? They have a doctor, they have a Medicaid number, they get their services paid for. If you feel that there is a service that they need that isn't one that can just walk in, now they may be in a managed care plan and you have to deal with that. Generally, when you get to the more difficult situations and you're getting pushback that Medicaid won't pay for it, if you get a doctor to write a prescription, this is a medically necessary service, that's the entry-level tool for fighting with ACA to get it paid for. So you've got to find the professional to make the prescription. The very short answer, there's a whole 3-hour training on EPSDT, and we have experts that can help in particular cases. All right. I apologize for having to leave. My kids are getting out of school early, but I am always available to take your calls and emails. Thank you. Oh, and the last thing, I did give you guys a card for our new website, Florida for Children and Families. This tells you how to sign up for it. Stick it in your wallet. When you get a minute to register or check it out, please do that.
I'll be talking about the Constitution. Actually, I probably will be working the Constitution. And before I begin, I just want to take a moment and recognize, how about Rosemary and Allison's extraordinary work with this. And to our guest speaker, the wonderful courage that she demonstrated in her path. And Yuri, I had the pleasure, well, Yuri doesn't appear to be here at the moment, but I had the pleasure of working with Ms. Barton-Jones when I was at the Office of the Public Defender. And to see her interact with the youth that she is charged, I absolutely understand why she refers to them as her kids, because they love her. And for many of those children, as you will see when you interact with them, she's the adult that shows up consistently. It's remarkable. She's remarkable to be with in court, and I am thrilled that I get to be with her again as we wrap our arms around these children. And in fact, Yuri could have given a much better discussion of the juvenile delinquency proceedings than but I'll do my best, and it's a credit to that office that they trained us so well that I can give this, I hope well, even though I've not been in the office for numerous years. Juvenile delinquency proceedings are civil in nature. As Yuri talked about, the children are faced with criminal charges, but those, while they're informed and obviously charged under the substantive criminal chapters of 775 through 896 Florida law, the proceedings themselves have their own set of juvenile rules. So, when you're looking for how these cases will proceed, there are juvenile procedural rules specific to those, and they cover the broad way, all the way from how a child is taken into custody through the various hearings. And I'm going to talk a little bit about that. Juvenile delinquency, although it is civil, a child is taken into custody. But that custody is not considered an arrest. And that's a very important legal question, because children often ask, do we need to disclose that I've been arrested? And actually, it's not technically an arrest. It's a taken into custody. It's only an arrest for the constitutional protections that are afforded the child. Now, when a child is taken into custody, as Yuri said, they have rights. And I'm going to talk a little bit about what happens, for the detention, what causes a child to be held in detention, the length of the detention. But I thought it would be helpful to begin my comments this afternoon on the legislative intent for the Juvenile Justice Act. The juvenile proceedings fall under Chapter 985, Florida statute. And when I was thinking about presenting today, I went back and I looked at the legislative intent. I'd like to spend a few minutes talking about that. The first thing that the Act talks about is to provide judicial and other procedures to assure due process through which children and other interested parties are assured fair hearings by a respectful and a respected court or other tribunal for the protection and enforcement of the child's constitutional and legal rights, to provide for the care and safety and protection of children, to ensure the protection of society, and you can see that there's a balancing there, so that the child's needs are recognized, and yet society is still protected. The fourth concern is to strengthen the child's family ties whenever possible, to assure that the adjudication and disposition is exercised with appropriate discretion, and that's really important. When you obviously, our charge is in the dependency realm, and the public defender, they handle the criminal aspect of the case. But in the cases that I've taken for Florida Crossroads, I attend all of the hearings, and I observe, because the court has broad discretion. And what the public defender's office does a very good job is to make the discretion work in favor of the child. It's wonderful in a unified family court where there's a judge with the sensibilities of Judge Stoddard, that he sees that there's this interesting opportunity to and I'm not saying that the judges in the pure delinquency bench don't do this, but Judge Stoddard well recognizes that there isn't a parent advocating for that child. So as we step into the shoes to assist Yuri in her advocacy through our dependency work, I really ask you to think about the discretion that the judges can have, and to fight to make sure the discretion works to the benefit of the child. The legislative purpose is also to give an opportunity for the discretion, and in fact the statute is to be liberally construed. The substantive law violations, again, are handled under 7075 through 896, but it's important that although the arrest, again, you get the constitutional protections, that the child isn't technically arrested. Not only is that an important thing later on when the child needs to make an application for a school or something else, but it's also a different total mindset, that what we have is children that are in custody, and hopefully we help to get them out of custody. But the certain enhancements that might be applicable to a child in custody under the adult code aren't necessarily applied to and I'll talk a little bit about that. There are cases that delineate that. Now, what happens when a child is taken into custody? Is it called a first appearance? They call it a preliminary proceeding as well, but it's a detention hearing, and that has to occur within 24 hours of being brought into custody. The Office of the Public Defender is present, and they're typically appointed straight out to represent the child. And the reason I want to spend a little time talking about this, even though it won't exactly be what we're asked to do, is oftentimes when I encounter children, it's been a couple of days, and maybe they've been through their detention hearing, and they want to understand what happened. And and the case manager may be a newer case manager, and they want to understand what happened at the detention hearing. So I'm going to spend a little time talking about the detention process. Within 24 hours, the child has to be brought before the court, and there will be some documentation that's present. One of the documentation, it will be a criminal report affidavit. Is everyone familiar with the criminal report affidavit? Okay, for those of you who might not be, it is an instrument that outlines what is the allegation, and actually what's interesting about the detention hearing is that within the four corners of that document whatever is charged, whatever provided, whatever the probable cause to take that child into custody must be proven up. So, for example, if the child is accused of a grand theft auto, they have to, with particularity, say this car was taken at this time or location in or about this address. It has to be within Hillsborough County. It has to be taken without the permission of the owner. All those elements must be present. So if it just said they were found in a car that was reported as stolen, I would argue and the car was reported as stolen at some point, but do we know that they were found in a car that the owner didn't give them specific, that they didn't have permission of the owner? Is that actually in there? And it can be that technical, because sometimes some judges are, a grand theft auto, it's her sister's car. Do we really know that the sister didn't tell her you could have the car, and the parents are angry? I mean, did anybody call the sister to make sure that this child doesn't have this permission? Because children are different. Children are different. And so one of the things the PD will do when they appear at the detention hearing is they'll say, Judge, they're accused of battery on a pregnant female, but it doesn't say that the woman appeared to be pregnant or that the child knew that they were pregnant. So, Judge, really we have a simple battery here. And what that does is it forces the court, if it's within the four, now if the alleged pregnant female or the owner of the car shows up and gives testimony, that's different. But one of the things that public defenders do an exceptional job of is attacking the elements. Lily, would you agree with me? Lily McCarty is actually a very experienced public defender previously. Would you agree with me that that's what occurs at the detention hearing? We attack the probable cause.
Yes.
Try to bring the charge down. Because why that's important, other than, the public defender would do this, but other than giving the child a glimpse as to the type of zealous representation that they'll get, is that it reduces the overall score in an instrument called the risk assessment instrument. Now, juvenile delinquency law is a creature of statute. It's any other law, but there are some very strict parameters on what judges can and cannot do. And I learned as a public defender that, again, to use the little window of discretion that the judges are given in terms of the prolonged detention of children. Now, the instrument that I referenced earlier, the risk assessment instrument, when a child is picked up, the Department of Juvenile Justice, by statute, is required to complete what is called a risk assessment instrument. And let's see, I think it's under Florida Statute 985-245. What this risk assessment instrument does, and we call it an RAI, is it calculates whether or not a child should be held in secure detention. The first pass that the public defender's office will make at that is to try to attack the probable cause, because the elements aren't met, as I said earlier, within the four corners of that document. The scale that is used to determine whether a child is continue to be held, and we'll talk about the child can be held in secure detention for up to 21 days. The scale there is, at least it used to be, and the public defenders I spoke with confirmed this, that if it's a 0 to 6 points, the child can be released. If it's 7 through 11 points, the child is held on some type of a home detention, or there's some type of a restriction. Maybe they get an additional curfew, maybe they get something. If there are 12 or more points, then the child is held up to 21 days. And 21 days is a hard window, by the way. Now, first we see the attack on the probable cause elements. And then we see sometimes, let's say it's something kind of egregious. Let's say it's an attempted sexual battery, or it's something just egregious that the court the child scores really high, but maybe there's some attack, and maybe it appears maybe it's a Romeo and Juliet, or it appears something's wrong. Sometimes the state attorneys, and although I don't want to unfairly characterize, because state attorneys are exceptionally fair, I found in my experience, if you can have a thoughtful discussion with the law about them. But, however, they may try to aggravate up. Now, really, there's case law that says, I think it's JJ v. Fryer, and by the way, I'm happy to provide an email to you with all of these different statutes and cases, that says that really any departure made by the court, that it must be in writing, and the evidence must be clear and convincing. So, if it's a particularly difficult up or down decision, then sometimes the state attorney's office will want to set a detention review for the next day. So you may hear that from your kid. They may say, we just had this detention review, but they wanted to set it again for the next day. And usually, sometimes the public defender's office will move and they'll make a motion of okay, we'll do another detention review, and then they may move for a petition for writ of habeas corpus, which I'll get to. But what the J.J. v. Fryer case says is that it's actually the question of a mitigating factor or an aggravating factor. It really goes to the risk assessment instrument, the person who prepared that. But later, after reading through the risk assessment instrument, later the judge can make a decision to aggravate or mitigate, but it has to be based on clear and convincing evidence. And so that's where the public defender spent a lot of time, and that was the part of it that I really learned from Yuri, is you spend a lot of time and you learn things about your kid. You learn that, the judge thinks I'm absconder or I don't appear, but really I've been moved so many times in different placements that I didn't have a way to get to court. I'm not trying to not appear. I simply can't appear. Or the adult that you left me with, or the adult that I was left with by someone got arrested and they couldn't bring me. So the public defender's office does an incredible job of finding out, and usually they work in teams. Usually there's one person in the courtroom reviewing the documentation, then there's another person securing the invocation of rights form, because as Yuri said, obviously these children have a right, they're represented by an attorney, and they shouldn't be questioned later. So then they come back before the court, and the public defender says, well, Judge, there's some mitigation here. And hello, Miss James. How am I doing so far? Great. Theda James, I'm sorry, do you mind, Rosemary? May I introduce Miss Theda James? She's actually the first lawyer that ever hired me. Thank you. You started this, and as the head of what? Actually, Miss James, I'm not sure of your title, but I know when I was there, you were pretty much in charge of everything. Is she still in charge? Okay, she's the chief. Anyway, so there has to be a clear and convincing record made, and the reason that that's important for us is that if the record doesn't support the decision to enhance and keep the child in detention, then the public defender's office may move for a writ of habeas corpus, and we can be there to assist in explaining to the child and in their dependency proceedings, Judge, this is what's going on, this child's in secure detention, public defender's office is working on it. Now, in addition to the risk assessment instrument, sometimes there are errors in the risk assessment instrument in terms of, well, what I've seen personally, and Lily, maybe you can, they probably have horror stories too. Sometimes when they do a risk assessment instrument on a particular, and this is a document that should be in the documents that Robin spoke about. They may, if there's let's say a burglary, and in the burglary there's a fleeing to elude, they may try to charge the burglary and the fleeing to, they may try to equate the time, the 21 days for the burglary, and then an additional 21 days for fleeing to, so they can stack those. Would that be a correct analysis, Ms. James? Yes. Okay. So that's something you want to, or you want to see if maybe there was this is something I used to see all the time when I was a public defender, and you want to look for this in your paperwork, because ultimately these errors can continue all the way through, and the public defender's office catches them. But as attorneys that help the child in a dependency proceeding, I think it's helpful if you understand that sometimes there are errors in the risk assessment instrument from something the child was never adjudicated on. Children are adjudicated delinquent. They're not adjudicated guilty. They're adjudicated delinquent. And also there can be a withhold of adjudication, and the court may choose to continue its jurisdiction over the child. But when you're looking at the risk assessment instruments, if the child's been in trouble a couple of times before, you want to make sure when you flip to the back page that the appropriate points are attributed to this detention score, and the appropriate points are attributed to the way this particular case is disposed of. And that's really important Because if that child had a parent there, that parent would go through that with that child and have a meaningful discussion about, look, you know, this isn't your first time before this court. You were alleged to have taken a car, and then there's drugs, and there are consequences for this. And when I talk to children that I have in dependency, I talk to them about, look, this is not a good pattern, and there are some other ways, there are some other things we can be doing with our time. And part of, I think, at least in my practice, is other activities. One of my workmates, Miss Alpert, has reached out and gotten one of her kids involved in karate, and it has completely changed the demeanor of that child. So I think there's incredible opportunities, and sometimes I get those ideas from looking at these risk assessment instruments. There was a young man I had when I was a public defender. He stole a lot of cars, and he loved working on cars. And he's alleged on several occasions to have taken cars he wanted to work on and maybe potentially resell them later for, you know. We worked that out. But I looked, there wasn't a single drug violence. The only thing that young man ever is alleged to have taken were cars. And I thought, I'd help him get a job as washing cars at a car lot. And he did. And then the owner of the car place liked him. He gave him a job cleaning up in the shop. I think the young man's fixing BMWs now, and he's making a great living because we connected. I think I've got to give Yuri the credit on that one. We connected what the child was trying to tell someone who wasn't around, like his parents, that he wanted to do, and instead he just did it. And when you're a kid that doesn't have anybody helping you, you make unfortunate choices. Like when Robin said, if kids get $15 a week allowance, you shouldn't be surprised that they're stealing. This kid was alleged to be taking cars because he wanted to drive and fix cars. So I think one of the things we can do is fill some gaps and help these kids. Okay, so I talked a little bit about errors. I want to talk a minute about fast-track cases because I think that's another area where I think, Rosemary, hasn't there been weren't we assigned to help on or asked for help on a fast-track case recently? Okay, so what are fast-track cases? These are cases where there's a child, and it's my practice, anytime I can put child, I try to use the word child instead of the child's name every chance I get. Because I never want the court, when they look at any proceeding, to forget that this is a child, and they should be afforded every benefit of a minor. And I think it, again, focuses the court, it focuses the attorney that's receiving the pleadings, but that's kind of maybe we have Judge Stoddard, who's superbly sensitive to that. In fact, Judge Stoddard appoints me on cases all the time, so maybe I need to. Anyway, okay, so the fast-track cases, what are these? These are cases where the state attorney recognizes that they are under a 21-day window that they can keep that child in custody. So they quickly accelerate. They quickly accelerate. First, I'm not certain that, and in fact, it's prejudicial to the child because it's a fast case. They get the child's in custody, they're quickly getting all the charging documents in place, and they charge the child. I've found, and maybe Lily, you can correct me if I'm wrong, I've found that fast-track cases are often the cases that are going to be referred to adult court.
Usually the fast-track cases that I experienced was that they were kids that they wanted to get into a commitment facility.
Right, exactly.
They wanted to fast-track it so they could hurry up and get the hold for the staffing. The direct file kids, they didn't even bother fast tracking.
They just direct filed them, right? But there's usually I would notice a pattern that if it was going to be a direct file, I guess the working operant here, and I'll talk about direct file cases in a minute. But the working operant, and by the way, this is Lily McCarty again. She's a public defender. In fact, she's got some very special activities that she has, and you'd be well served to introduce yourself to her after the presentation. Okay, so again, we talk about the 21-day window. They can keep a child in secure detention for 21 days. They can also, under statute, it's 985-255, they can keep a child longer, but they have to actually, with good cause shown, and make that before the court. when I was a public defender, and the public defender's office does a great job of this, they file writ of habeas corpus to get the child out. And there's really good case law on both sides of that, depending on the nature of the charge, the need to protect society, the past history of the child, and absconsion. They have to prove up the absconding, and that's a pretty interesting hurdle. So that's some things you can keep in mind in your discussions with the public defender. But the fast-track cases leverage the detention of the child, and children do very interesting things when they are, because look, these kids, our kids have interesting interrupted lives. Then they get this kid, and this kid might be used to living in several different places, or being on the run, or being, more liberated than maybe your typical child. So they take this kid, and now they're in lockdown. And one thing that PD office does is very well is to talk to the child about not making any statements to law enforcement. But you're going to see kids do some very interesting things when they're locked down after 15 or 20 days. So, that's, I think, a place where we can really be helpful to go and assure the child that they have representation. And to assist the public defender with helping to manage this child in terms of feeling all right that there are things going on. I spent a lot of time on filing habeas corpus petitions when I was a PD, and whatever PD is assigned, I guess it would be Yuri, please talk to her about that. Let's see, just to give you a little bit more of the law, a child may not be held in secure, non-secure home detention, under special detention for more than 21 days, and unless an adjudicatory hearing has been commenced in good faith. In this county, I don't see that being a problem as much in terms of a lack of good faith. I did have a case up in the upper part of the state where they had held a kid for 52 days. Maybe it was not quite, it was almost double the amount, but it wasn't a lack of good faith. It was just an issue with some of the other people in they couldn't get the child placed properly. I think that's one of the things in terms of our sensitivity to the delinquency proceedings that we can help with. Now, there is an exception for the 21 days, and that is domestic violence. If there's a problem with the child having, let me phrase that differently. If there's an issue where a child is accused of an act of domestic violence, then the detention may last longer than 21 days. However, there has to, again, because all of the juvenile justice is, the purpose of it is to protect and care for the child properly, the child's interest in being placed properly come into play. One of the things I have a couple of kids, that some of which I have through Florida Crossroads, and some I have just through Judge Stoddard appointing me. Sometimes finding the right placement for the kid takes some work with the case manager. There was a case I had that involved domestic violence, and the alleged victim indicated they did not want the child to return to the home. The child could have been held up to 21 days, but I asked for the public defender to say, okay, can we find some additional placement? I found another family member that would be willing to take the kid. And so that was some things that I was able to, although the public defender's office has wonderful social services, there's a really high volume that office does. So I think stepping up and helping when possible is really important. The case managers bring the children to the delinquency proceedings and to the dependency proceedings as well. Every opportunity I have to meet with the case manager, I do. And I also visit the children that I have in their particular placements. I don't have any children right now that are in secure detention. I thank Ms. James, great lawyers, for that. I did have a young man that was incarcerated in Hillsborough County Jail, and I worked with the public defender's office to figure out what's a better place for that kid. And we got him out, and he's doing pretty well. I know I went pretty fast through some of the law in terms of detention. If anyone has any questions about that, I'm happy to answer it. These proceedings go just as a regular criminal proceeding might, except the child doesn't get a jury trial. It's a bench trial. The rules of discovery are fairly similar. The window for discovery is shorter. However, once you put in a discovery demand, I believe under the juvenile procedural rules, it's 5 days. that it must come back. That's why this fast track window is kind of compressed. The juvenile delinquency proceedings are before the circuit court. The ones that are just delinquency, obviously the crossover kids that we have are obviously also before the circuit court. There is, you can set depositions for Class A witnesses without leave of the court. It's the same. You may introduce a transcript. All the rules of evidence are in play. You may use a transcript. For example, the public defender often deposes people, and then they will impeach witnesses, and it's as if it's a fully briefed case. Although it is it's a civil proceeding. The Office of the Public Defender is still appointed to represent the child because the child's liberty is at stake. Is there any further? And of course, as it would be, and I probably don't need to say this, any decision is obviously appealable. When I was a PD, I would move for rehearing, and then I've done appeals. And some of the best case law there is our juvenile cases. In fact, there's a really wonderful case that I'd like to recommend to you. It's BM v. Dubuller, and it's 979 Southern 2nd 308. And this case really talks about all of the issues that come up when children are taken into custody. It talks about, the limited powers of the court, the best interest of the child, what's the legislative position on detention, which is detention should be used only when less restrictive interim placement alternatives prior to adjudication and disposition aren't appropriate. This case talks about, what does it need to rise to before the child can actually be considered an absconder. And there's a whole discussion about, a diligent search. And I would invite you to look at that, because oftentimes our kids are branded as absconders, and they're not absconding. Their person got arrested. Now they're in foster. They've been placed, and maybe their placement changed, and now they don't have clean clothes to wear to court. So it's not that they've run away. They're just not present in court. I think we can do a great job of helping to connect those dots to benefit the children. I have to tell you, I do a lot of interesting work as an attorney. Great, wonderful practice with Rosemary's husband, Sandy Weinberg, fabulous lawyer. But there's really no work like this stepping in to help these kids. I have a kid that was a victim of, he's a foster care kid because she was a victim of sexual violence. And Judge Stockard called me and said, I'm going to appoint you on this case for this child. This is several years ago, actually. And I said, well, she's going to have a public defender. He's like, no, she's not in any trouble. She's in foster care because she told on the person who's alleged to have attacked her. I said, okay, well, what do you want me to do? And he said, I want you to save her life. And I'll tell you what, I've represented people. I've been accused of a lot of things, and I was trained by Theta, so bring it. I got great lawyers that I work with. I got a lot of passion about this work, but when a judge says you got to save her life, that's something. The work that I was supposed to do on that case ended a long time ago. We got her properly sheltered, but I'm still her attorney, and I can't wait to come back and tell you guys we've gotten her into college, because that's what the goal is. So, I talk to you about delinquency all day, but you'll think the rest of your life about the children that you help, and it's an honor to come and share this with you. Have I gone too long?
No.
Yeah.
In fact, I wanted you to talk at length, if you can, about direct filing of children to criminal court.
Okay, and I'm going to invite, if it's okay, Lily McCarty, who does a lot of this, to help me with that, because direct filing is, okay, to my understanding, you have a child that's brought in. Typically, the instrument that charges children is a petition for delinquency. Again, it's a civil proceeding, right? Maybe there are certain types of cases that the court will permit, that statute permits. Although I guess you could say the discretion of the state attorney is such that they could choose to file almost anything as a directly, depending on the age of the child. That's really what it is. Lily, what's the cutoff on that? It's 15.
16
16.
and above for any felony.
Right.
14 and 15 for certain specified felonies.
Right.
They can direct file 16 and above for misdemeanor. I've never seen it happen.
I've never seen it either, right.
But 16 and above, any felony,
Uh,
regardless of their criminal history.
Right. Okay, so we have a child that's taken into custody, remember, not arrested, for a felony. And there's something about this case that the state attorney is deeply concerned about. So they make a decision to direct file the child. And a direct file is, instead of being handled under Chapter 985 that I talked about, now the child is being treated as an adult. The public defender's office, has a kind of a, and maybe, they could describe this better, but I remember when I was there, if a child's direct filed as an adult, there's a whole team of people that get together and they talk about what can we do to protect this child. So, in terms of what the public defender's office does, maybe Yuri can talk about that for direct filing. But direct file cases are where I think we can be the most helpful, because these are kids that now don't have all those extra protections of being a juvenile. They are now being treated for the purposes of the charge as an adult. However, yes, Miss James.
I think Lily was our pre-file advocate.
Right.
She was charged with the mission of trying to keep children out of adult court, and I think that's where you all can be very helpful, because when she was doing that for us, we had a lot less filings in adult court. And you're right, but once they get filed,
right,
they're only handled by division chiefs, felony division chiefs, and you have a mitigation specialist on board. But the goal is to keep them out of adult court, and Lily was very successful at that.
Actually, yeah, and in fact, Rosemary, I know it's a little bit of a variance, but would you mind if I asked Lily to just, please, Ms. McCarthy?
Sure. I left the public defender's office just under a year ago. And when I was with the public defender's office, my job was to reduce the number of direct file juveniles in Hillsborough County. We lead the state in how many children are in adult court. In approximately 2007, 2008, Ms. James, I think we were about 600 kids a year. The last year I was there, we were down about 250 children a year, but we still led Miami-Dade, we still led Duval. I think that there's a lot of reasons. I won't go into why I think we have more kids in adult court in this county than any other. There are a lot of things that we can do to prevent that. What we see happening is a lot of kids piggybacking with adults or kids that are recently turned 18 years old being direct filed, so that all cases are handled for judicial efficiency in one courtroom. And what we see are a lot of 15-year-olds that are charged with being accessories to adults, or 18-year-olds or cousins that just turned 18. And these kids really having minor roles in the juvenile justice system, in the crime, if any role at all, and they're being pulled into adult court. I had one juvenile that I represented at 17 that was direct filed for tampering with a crab trap, and the reason was that he had a prior robbery from a few years before. And I think that there's such inconsistency and no rhyme or reason as to why the kids are getting direct filed, and it's really because there's not one attorney that makes a decision. It depends on what intake attorney at the state attorney's office gets it. So you have different personalities making decisions on direct filing, and there's not one, person looking at it that makes it. So it's not a consistent personality making a decision. What you can do is, if you have a juvenile who is at risk of being direct filed, is assume that they're going to be a direct file, and then act as everything you can do to prevent it. And that's why the mitigation is so important from the very first day that they get arrested. Presenting every single thing that you can to the state attorney's office. What I tell juveniles, and I've had some in private practice as well, is I tell their parents the first day that they're arrested, I say, I want you to go down to school, and you have to go to their school, and you have to go to the Velasco Student Services in Ybor, and I need a copy of because it goes to the parents' hands immediately, if there are parents involved. If not, then I walk down with a signed waiver. The HKI worker will sign one. But, and I say I want their school records, I want their educational records, I want their disciplinary records, and I also want their psychological records, because a lot of times kids will be seen by school psychologists, and you see the repeated trend throughout the years of having the same problems over without real true interaction or dealing with those problems. I had a kid, and when I can, I try to represent them at their change of placement hearings at the school as well. I went down to a hearing one time you opened a door.
No, please, because you know what? We did this, yeah.
I went down to a school board hearing, and this was when I was still working for Ms. James, and the school board said, this child is a real problem, this child had 23 referrals, and this, and I said, wait. Why are we here at a change of placement hearing because he was arrested on something that had nothing to do with school, but because it was a felony and off school grounds, you have a change of placement hearing. Now you want to put this kid in adult school and you're telling me here he's had 23 referrals? Where were you on referral number 5? Where were you on referral number 10? Where were you on referral number 15? And now that there's a criminal charge and you have to worry about, you know, being exposed for the problems, why are we now saying he's a nuisance and it's 23 referrals? Where was the school social worker being appointed to evaluate this case before? And I think that our school system does a good job. I'm not saying that they don't, but things shouldn't be slipping through the cracks like that. 23 referrals is that's too late. That's too late in this child's life. We need to be more proactive. And, you know, I think that getting those records, seeing the child's history in school, is the child even going to school? Our parents even sending them to school? And I think Judge Stoddard hit it on the head. He said a lot of these issues are undiagnosed dependency issues. And so we have to really look at those and address those. There also just needs to be consistency and the mentoring in the community. There needs to be consistency in the services that are available, and a lot of services are out there, but there's so many of them that they're diluted because there's not a source that someone can go to and say, I need to find help, where do I go to? And as well, it's just making sure that we become involved. I think that we all have to take on our own personal responsibility, and I'm a big sister to big brothers, big sisters. I try to be involved in that way, and I used to go into all the community churches and organizations, schools, you name it. I presented a direct file presentation because most kids don't realize they can get direct file. So usually Miss Marie Marino over there does phenomenal with mental health. If you ever have a mental health question, that's who to call. And there's so much that can be done for kids. It's just that not a lot of people know how to get to the resources.
So, I mean, no, really, thank you. I mean, really, stopping the direct file stops the train before it pulls out of the station.
Correct. And once the children are direct filed, it's a lot harder to get them
to back off that decision to direct file
because
them.
no judge wants to be the judge that took the risk on a child and then they commit another crime. But what we see is a lot of children that probably should go into a residential treatment where they get a vocational training and some kind of an educational training, as opposed to going on adult probation or going on community control. No child can. No adult can do probation. How is a child going to do it? So that's also as well. And you commented earlier, a couple of years ago, there was a problem with EJJ where when children were being placed into high-risk commitment programs, that the statute says that if they go into high risk, that they're able to be held until a bed's available, regardless of time period. And it was taking months to get beds available. But I saw Ms. Royston walk in. She's now the chief probation officer. That was when I was at the public defender's office. That time window greatly improved. And that was years ago that we were having those problems. But that's kind of where you see that extended time period is in between adjudication and being placed in a higher risk facility. So, and there are also, if you do have a juvenile that's direct filed, and I'll sit down just a second.
No, please.
I haven't had an opportunity to talk about it. If you have a child that is direct filed into adult court and there's something that they want, they want the child to go to prison. There are two in the state of Florida. There are two maximum risk commitment facilities that are I think in my career I've only seen that maybe 5 or 6 kids ever get placed into a maximum risk. And I used it on a direct file robbery charge in Hillsborough County. The child was sworn to prison. The child had a pretty serious record, and the state attorney wanted the child to go to Florida State Prison. And I said, look, I understand that you want the child to go. This is a 16-year-old child. Can you consider this program? And it was a maximum risk. It was up to 36 months commitment, but it's also education, and it's not just being warehoused in a prison. And we did negotiate for that sentence. So he has a juvenile conviction, but he did get incarcerated. I think there's one in Okeechobee and one in, I can't remember where the Cypress.
Cypress, right.
But there are two in the state of Florida maximum risk level 10 facilities that if that's the only alternative there is, that you can also present that to the state attorney. And also working with the JPOs, making sure that the JPOs, the juvenile probation officers, are helping, and you can get some really great JPOs.
Right.
The only problem one other thing, caseworkers, I know they're busy and I know they're overwhelmed, but I had a sex case where my client was 15 years old, mentally ill, handicapped, or borderline mentally retarded, handicapped, mentally, everything, you name it. He was in a DCF placement and accused of molesting another child in the placement. And when the sheriff's office called the caseworker and said, hey, we want to interview this kid, the caseworker said, go ahead. And my position is that the caseworker should, even if they drive down to the station and they tell the kid, you need to cooperate, you need to tell the police officer what you did, that's still being there for the child. And I think that just telling the police officer, go ahead and talk to her, I don't need to be there, is where we need to see that that is not happening.
Right.
So.
Wow. Thanks, Lee. Yes.
I have a question, and maybe directed more to Marie. What does Miss Boatwright do exactly?
You want to I can defer that to Yuri just because she's in the crossover division.
Ms. Boatwright, she's Judge Stoddard's case manager, basically, and she does a lot of the cases that are dealing with the dependency kids, and she will review a lot of those files. She knows a lot about what's going on with the kids' history. She's also doing now behavioral assessments. She's also doing interviews with some of the kids in the DJJ system and some counseling with them. She has a plethora of knowledge.
Yes.
Yes. She goes into the detention center. She's doing counseling with some of those kids and the families. She's a good resource, excellent resource when it comes to wanting to find out more information about how can I get in contact with a case manager. I can't find the AG. Nobody's calling me back. She'll get a response for you ASAP.
So she works for the judge?
Yeah, she works for the court system, in the court system, but she's Judge Stoddard's case manager.
Rosemary, that would conclude my remark. Oh, Sarah, sorry.
I have a question. I don't know if it's for Lily or for Eurydice, but if we're, as a crossroads attorney, and we're representing a child in dependency, and they're in delinquency as well, and you want to mitigate, as you said, the direct file, and I understood, Lily, from your remarks that perhaps the best way is to make a presentation about the child's history to advocate for why they shouldn't be direct filed. How can we, as the attorney ad litem, assist the public defender's office with that process? Because you're still representing the child in delinquency. So should we, is it something of a matter of preparing a written, maybe a written statement that, we can use, or meeting jointly with the state's attorney? I'm not, sure how to, actually make it happen when we have to do it.
The window of opportunity is so short when you're dealing with the direct file potential, because first of all, if the child's incarcerated, the child is in detention, there's only a 21-day window, and what you will see happen is they'll want to wait till the end of the 21 days, so the child is on DCF's dime longer than they're on the sheriff's office dime. But then at the end of the 21 days, they'll be direct filed and taken over to Orient Road Jail. You really, within a week of that arrest is your window, and you need to get every single thing that you can get on this child. A lot of times public defenders just don't have the ability to go drive to get the record. So get any record you can, any supporting documentation. You may not necessarily need to write a mitigation letter, but just say, look, I'll get you whatever it is that you need to show, or if the child's working, to get proof of employment, to get witnesses that will help, present the evidence, even if it's, because then you can do a factual mitigation, saying, look, the facts of the case don't support the charges. Or sometimes I could say, I've given them, I've given case law that says, look, this doesn't support, this charge. This is what the second district said about this recently. Or this is about this child, and yes, the facts are bad, and the fact that you have the facts and you can file it, but this is why this child shouldn't be direct filed, and that's another way also to propose it. So I think just gathering the information they need.
Yeah, Lily's right. Gathering documents and information. Before, we had one point of contact. Now we don't have Lily, and that's been delegated to the division chiefs, the juvenile division chiefs. So you can contact me, and then I'll find out what division the child had the detention hearing in. And so it would be the juvenile division chief who's going to be doing the pre-file advocacy. Okay?
And if you remind me, I'm also going to try to answer that question a little bit.
I want to add one thing. We had one case, one of our kids who was direct filed, and we had to bring it to the state attorney's attention, the age of the child. They had it on the CRA, it was incorrect that the child was 16 years old. And that was the reason that we used them to direct file my kid. And I got in contact with the state attorney who was doing the direct file immediately, like Lily said, very short time period. And I had to present to them, the age of the child is incorrect, number one, and number two, the charge that they were filing, it didn't match up. So they took a look at it and they decided to bring both of the co-defendants back into the juvenile.
And that happens more than you think.
Right.
When I would look at the dockets after court, I would look at what kids could be direct filed. And if there were kids that couldn't be direct filed, obviously I didn't review those because my job was direct filed. And I would get, I think probably at least 4 or 5 times a year, I would get a call from a parent, my child's been direct filed, and I'm, why? You know, and we would file a motion to dismiss because of jurisdiction because children were illegally direct filed. It was either a charge that wasn't direct file eligible or they had the age wrong. And so those are things that, you know.
Can I add something?
Yeah.
Because I'm an assistant public defender too, and I do work on the mental health. The state, in every case I've worked with in this pre-file advocacy capacity, the state is of the belief that they have to file them as adults so they can get treatment. And if you all are experts in the dependency area, because that's how you're working with these kids, they don't know what these kids have available to them. A kid is no more available to any resource because they're direct filed as adults. Just the opposite. Once they're direct filed, all these children's resources don't want to touch them anymore because now they're in the adult system. We can't get kids out of jail under the age of 18 because no group home, SIP placement, nobody will work with a kid once they're direct filed. So if you're filled with an arsenal of information about the dependency side, which does not readily belong to any of us, that is going to be incredibly helpful because what we're doing is educating the state, all these resources available to this kid that they will lose when they have this distorted belief that because they're direct filed, you know, there's going to be more resources available to them. And I don't want to totally flip-flop, but the 12 and under population, we're top 3 in the state of Florida filing on kids 12 and under. So we've got a problem on the 16 and over and equally on the 12 and under. And if you want to see kids coming to juvenile court who can't even reach the podium, and you know, Judge Stein hit the nail on the head, half of our, so many of our delinquency cases are diagnosed dependencies, undiagnosed, excuse me, dependencies, because that's why you go in. You just start unraveling. This 9-year-old is eating meals at a neighbor he doesn't even know his house because his mom's drunk, getting beaten by boyfriends and totally neglecting him. And what hurts my conscience is that's in the police report when they file all these felony charges on this kid for piggybacking with older kids out in the community when they broke into some kid's car. Okay? I mean, and then they're filed on as a 9-year-old, and you sit there and competency becomes an issue, and that starts the whole ball rolling, because when you're 9 years old and you're incompetent due to age and immaturity, there's no treatment or training or anything provided to you. We just have to wait till they get older. So, you know, if we don't catch this early and ask to address the real root of these issues, it's not going to get caught. And I really hope in a lot of these cases you guys can support the public defender, because we're representing their criminal interests, but their expressed interest is not represented in the court system. And their best interest is often their expressed interest, but so many times it isn't. And until that mouthpiece is given to these kids, we're real fixed putting circles into square pegs.
There's just one other thing, I'm sorry. You talked a little bit about the fast track cases.
Yes.
And those fast track cases, I think, they cause a lot of problems for these kids.
Absolutely.
But what you see a lot of times with these juveniles is that they'll get out of custody or out of detention. they'll pick up a new charge, and then both cases will be set off. And then they'll pick up a new charge, and both cases will be set off. And so it's kind of a snowball effect, and then they get direct filed, and all those pending felonies go to adult court. So, you know, this child is now in adult court with, you know, anywhere from 1 to 10 burglary of dwellings, and each one, you know, is level 7, and the score is outrageous. So that's why if you have a child in the juvenile system, and you see that there's a pattern developing where they're picking up arrests rapidly, you need to make sure that those cases, you have to effectively represent the client and make sure this child is taken care of. But remember that there's got to be a time clock ticking in your head as their attorney, because you don't want lingering felonies if they pick up a felony and get direct filed.
Right, right. Well, I guess these kids are at an interesting crossroads, aren't they? Yes.
Yuri, I have a question for you. I believe you'd be the appropriate one to answer it. We represent several crossover kids, and we're finding that the placements are not in Hillsborough County. What's going on with that?
Well,
At Jacksonville, Lakeland, Vero,
Orlando.
Yeah.
that is, it's a nightmare, to say the least. And the reason why I think some of that's happening is because we're being told by the case managers that the child has outstayed their welcome in Hillsborough County, and in a placement. They can't find placement in Hillsborough County, so the child now goes to Jacksonville or Orlando. I had a kid about 2 weeks ago that was out of county in Orlando for over a year, and that particular child is doing he's doing services in a Walker plan. He's doing excellent in his placement. Case manager comes to court and says DCF is going to be moving him because he's overstayed his welcome in that placement, and they no longer can have him there because it's a jurisdiction issue. So he's in the middle of successfully completing this very important Walker plan, and they're getting ready to yank him from his psychological evaluations, from his counseling sessions, of which he's already created a rapport with his counselor, doing well on. And the kid is telling me, Ms. Barton-Jones, I don't want them to move me. I'm doing well. What can you do to help me? I had to bring this to the judge's attention, because now my child could potentially fail out his Walker plan because of a placement issue, because of money, or also because of them not finding proper placement in Hillsborough County. They'll tell you that because the kid ran away umpteen times from a certain placement, well, they figure that they can taper down on the running away by putting them in a county where they don't know their surroundings, and that's what they'll do. So that's the way how they come up with a solution, some of the times, rather than getting to the root of the issue.
So especially when you're trying to build a rapport with your client.
Exactly.
Which is so important.
Exactly.
You're so far away.
Exactly. And I have to, what I have to do is, again, hold the case manager's feet to the fire. They'll tell me, well, my kid is in Jacksonville. I said, well, my kid has felonies. Bring them to my office. Because just like how you got them there, they need to come to their attorney. Right. And it happens. They bring them. So you've got to hold their feet to the fire. Don't let them tell you all of this impossible stuff. And don't let them tell you, this was one of their favorites in the beginning. We don't have a place for that, Judge. Can they stay in DJJ? And I would be jumping up and down, opening up the statute book, and like, you can't do that, that's illegal, So, that's some of the stuff that they like to pull over our heads and tell us what can and can't be done according to their agency. And then I like to point them to that big book we have in the courtroom that's called the statute. And I let them know, well, this is what's legal. This is what the judge can and can't do, and this is what we're going to be advocating on behalf of our client.